Let's continue with the Miranda decision in Lesson 41, as well as some other landmark due process Supreme Court cases. Picking up with the Miranda decision, following the decision, the nation's police departments were required to inform arrested persons of their rights under the ruling. This became known as the Miranda warning. In fact, to Mirandize a suspect is to read him of his constitutional rights. Also from the majority opinion, if the individual indicates in any manner at any time prior to or during questioning that he wishes to remain silent, the interrogation must cease. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any subsequent questioning. It was a 5-4 decision. Justice Byron White, one of the dissenting justices, wrote in his minority opinion, "I have no desire whatsoever to share the responsibility for such impact on the present criminal process. In some unknown number of cases, the court's rule will return a killer, a rapist, or other criminal to the streets and to the environment which produced him, to repeat his crime whenever it pleases him. As a consequence, there will not be a gain but a loss in human dignity." So the question is after the Miranda decision, were there a number of convicted criminals who were set free because they were convicted on the basis of their sworn confessions? Not really. But there were a couple of high-profile cases that gained a lot of media attention, such as Jose Suarez, who had confessed to killing his wife and 5 young children, stabbing them more than 100 times, and he was released because he was convicted on the basis of his sworn confession. What happened to Miranda? His case was retried after the original case against him was thrown out. And this time the prosecution, instead of using the confession, called witnesses, including his wife, who testified that he had told her of committing the crime. And they used other evidence as well. Miranda was convicted in 1967 and sentenced to serve 20 to 30 years in prison. He was paroled in 1972. After his release, he returned to his old neighborhood and made a modest living autographing police officers' Miranda cards, which contained the text of the warning for reading to arrestees. He was stabbed to death during an argument in a bar on January 31st, 1976. When the police came to arrest the guy who stabbed to death Ernesto, they read the guy his Miranda rights. Oh, the irony. The Miranda decision was widely criticized when it came down, as many felt it was unfair to inform suspected criminals of their rights, as outlined in the decision. Richard Nixon, president at the time, and other conservatives denounced Miranda for undermining the efficiency of the police and argued that the ruling would contribute to an increase in crime. Nixon, upon becoming president, promised to appoint judges who would be strict constructionists and who would exercise judicial restraint. What are my thoughts on Miranda and the Miranda ruling? I think it was another victory for the U.S. Constitution. In other words, law enforcement officers, get it right. Be competent. Have it together. Dot your I's. Cross your T's. Read the card when you arrest somebody if you cannot memorize the Miranda warning. It's not that hard to do. It's not that hard to be competent. It's not that hard to do your job and do it well. The next Supreme Court case dealing with due process is Escobedo versus Illinois, 1964. Danny Escobedo had a brother-in-law named Manuel Valtierra. Manuel Valtierra was shot in the back of the neck and died instantly on the night of January 19th, 1960. Escobedo was arrested without a warrant early the next morning and interrogated. However, Escobedo made no statement to the police and was later released that afternoon. Subsequently, Benedict DiGirolamo, who was in custody considered another suspect, told the police that indeed Escobedo fired the fatal shots because the victim had mistreated Escobedo's sister. Danny was a 22-year-old high school dropout. He loved his sister Grace, but did hate her husband. Her husband beat Grace often, was once arrested for stabbing her more than a dozen times. On January 30th, again, the police arrested Escobedo and his sister Grace. While transporting them to the police station, the police explained that DiGirolamo had implicated Escobedo and urged both him and Grace to confess. Escobedo again declined. He asked to speak to his attorney, but the police refused, explaining that although he was not formally charged yet, he was in custody and could not leave. Keep this thought in mind. This is important. They told him he could not have an attorney because he was not formally charged. His attorney went to the police station and repeatedly asked to see Escobedo, but was repeatedly refused access. Police and prosecutors proceeded to interrogate Escobedo for 14 and a half hours, and Escobedo repeatedly requested to speak with his attorney and was refused that request. For 3.5 hours of the interrogation, Escobedo's lawyer was actually at the station and demanded to see Danny, but was denied. While being interrogated, Escobedo made statements implicating his knowledge of the crime. He was convicted for murder in the trial, but his lawyers appealed on the basis of being denied the right to counsel. He admitted that he offered DiGirolamo $500 to kill Grace's husband. DiGirolamo was tried, convicted of murder, and sentenced to life imprisonment. Escobedo was tried and sentenced to 20 years. The case goes before the Supreme Court, the lawyers arguing that the statement Escobedo made during the time he had not been permitted to see his attorney should not be used against him. Any statements that Escobedo made during that time in which he was denied to see his lawyer, those statements should not be held against him in court. It was a 5-4 ruling by the court in favor of Escobedo. The Supreme Court recognized a suspect's right to an attorney during police interrogation, even if the suspect had not yet been charged. So you have that Sixth Amendment right to counsel, even if you have not yet been charged. Once the police start interrogating you, you have that right to counsel. Escobedo versus Illinois. This ruling extends the right to counsel to suspects from the time they become primary suspects. At that time, as you can see on the cover of Time magazine, landmark case, Escobedo. Have we been indicted and require me to invite your attorneys? I think not, but you don't have to be indicted to have counsel. Once you are a suspect, once you are being interrogated by the police, you have the right to counsel. Sixth Amendment and the Bill of Rights. Gideon versus Wainwright, 1964, another case involving the right to counsel. Very famous case. Here's the background.